Thank you for joining us. I'm Mary Yanez, Director of the Senior Adult Program, and this is Mature Living. Believe it or not, we have a wonderful program planned for you. And of course, Bob Warwick is responsible for inviting wonderful guests. You're going to be talking about some interesting topics. I really appreciate what you're doing for Mature Living.
Well, I appreciate the opportunity, Mary, and I hope everybody enjoys what we have for them today.
Well, let's watch.
Okay. Thank you, Mary, for letting us come today. And I want to introduce myself. I'm Bob Warwick, and the guests are Victor Falvey and Magda Soto. And today we're all attorneys, and today we're going to talk about probate, wills, powers of attorney, trusts, and guardianships. But I do want to make a disclaimer at the very beginning that don't take this as legal advice. This is a general discussion, and maybe it will set something off in your thought processes that you should go and talk to your attorney and see if you have your estate plan the way that you want to have it set up. So I'm going to start with Victor today, and maybe you can just tell the audience what probate is about.
Well, probate is a process in Texas where either your will is submitted for determination as for letters or letters testamentary, or if you don't have a will, process of declaring your heirs and determining how your property that has been left is transferred on your death.
And one of the big distinctions, I think, and we'll have Magda talk about this, is the difference between dying with a will and dying what we call intestate, without a will. If you have a will, you can tell the world who you want to get your property. Is that correct?
Correct.
But what happens if you die without a will?
That is the biggest unfortunate. If you die without a will, then the law dictates who is going to get your property. And of course, unfortunately, if you die without a will, there's usually two attorneys involved, so the cost of probate also usually doubles.
And that can get costly, but if you do have a will, Texas has a pretty expedited and relatively inexpensive probate process. Is that correct?
Correct.
One of the big distinctions there, I think, is in 1993 the law changed. Is that right?
Correct.
And what was that big change?
The big change before was if you were married and you had community property, such as a house, and you passed away without a will, your 50% in that house went to your children. September of 1993, that law changed. So if you die without a will and community property, such as a house, then that share does go to your spouse.
Except that, now we'll put Victor on the spot here. What happens, Victor, if you have children from different marriages, even if you die after 1993?
Well, the rule didn't really subjugate them or change it, so children from a prior relationship or prior marriage still take as though the community property is split.
So that's really important. I get this a lot in my office. And I don't know if you get this a lot in yours, but somebody will come in with a will and say, my husband or my wife died 6 years ago. I need to probate my will because there are children from a prior marriage. What's the problem there?
Well, first of all, you're beyond the 4 years of the time period under the law to probate the will. And secondly, now you're going to be limited as to procedure, what's going to happen, which could be a muniment of title if the proper notices and citations are given, waivers are received from children. But if not, it's going to fall in or be probated as though there was not a will.
And I don't want to get so tangled up in this because it can get pretty complex and pretty tangled, as you said, but we want to make sure that everybody understands that the will must be probated within 4 years to really have an effect. Is that right?
Yes, sir.
And what a muniment of title is a special kind of probate. And you can get the will admitted as a muniment of title after 4 years only if all the beneficiaries or heirs agree that it can be admitted to probate.
Correct. And of course, the definition of who's the beneficiary and heirs changes dramatically outside of the will, especially if there's other families.
Right. So now let's say, I'll give you this problem, Magda. Now let's say you have a will, you have not probated it in 4 years, and there are kids from a prior marriage that don't necessarily get along with the surviving spouse. What's the big problem there?
The big problem there is now you have to notify those other children that you are going to probate the will, and they have an opportunity to contest this will being accepted into probate.
And it's not so easy having the will admitted as a muniment of title, especially if there is not agreement among, let's say, children from a prior marriage. Is that right?
Correct.
You have to meet certain requirements. And what are those requirements?
Well, you have to have, of course, a good reason as to why you did not probate that will in the first place. And you have to give notice to all of the children. And again, it opens itself up to this could be contested and your will could be shown that it's not going to be admitted into probate.
And there are very few really good reasons why you should be able to probate that will. Is that correct?
Correct.
You can't just say, I didn't know I had to probate it.
Unfortunately, no.
You can't just say, I didn't have the money to probate it.
No.
You can't just say, well, here's the will. It says I'm the executor and I get everything. That's not sufficient, is it?
No.
Victor, that's another problem I face, and I don't know if you face this. After 4 years, somebody comes in with a will and they lay it down in front of you and they say, I want the house. You need to do a deed to the house and I'm the executor. Can you do that?
No, there's no power in the executor unless the will has been admitted for probate, either under letters or administration or immuniment.
And that's a really important part. A will means nothing, really, until it's admitted to probate. Is that correct?
Well, exactly. You know, there's 3 basic tenets for the will. Number 1, the individual has to write it and has to have the intent to write it. Secondly, the individual has to pass away. And then thirdly, the will has to be probated.
And once it's probated, you get something, if you're named as the independent executor, you get something called letters testamentary.
Correct.
And what do those allow you to do?
The letters testamentary allow you to act under the will as though you were the person who wrote the will. So as the executor, you have the duties to act as the final instruction from the testator, the person that wrote the will, as to what they want done with the property that they left after their death.
And so somebody dies and you're the spouse, let's say the surviving spouse, and all of the accounts are not in both names. So you call the bank and want to get information on the account that's just in the decedent's name. What happens?
Well, the bank's usually going to tell you, no, I won't do it or I can't do it because you're not on the account.
And, this brings us to, there are 2 types of probate, or there are 2 types of assets. They're probate assets.
Correct.
And they're non-probate assets. What are non-probate assets?
Well, non-probate assets can be accounts that, say, have rights of survivorship on them, insurance, items that are designated. It's usually more personal property than it is real property, although in Texas now there is some right of survivorship standards that are a little different that have changed, but you still have to get the declaration under it, which is order and an adjudication by a court.
So if they're non-probate assets, that means that they trump any provisions in the will. Is that correct?
Well, they don't enter into the will, so they're considered as not part of the estate that's left over by the decedent.
To wit, non-probate assets.
Right.
All right. So again, I want to make this clear because at least in my experience, there's a lot of misconception, I think in Magda's too. When somebody comes in, we always attempt to explain that just because the will says, let's again use an example, the surviving spouse gets everything. If there's an insurance policy that leaves it to the children, the insurance policy goes to the children.
Correct.
All right. Another thing that I think we mentioned, or you mentioned, is that the will is only effective after someone dies. You can't attempt to use it for anything before that occurs.
Well, and there's exceptions to that typically. I mean, if somebody is lost, they can't be found, they might be declared to be dead or no longer to be in existence. So the will possibly could be admitted then at that situation. But typically the will doesn't mean anything until it's probated.
And until, again, the person dies or is declared dead.
Correct.
And is that, Magda, a major difference between powers of attorney and wills?
Big difference, because of course powers of attorney are effective while the person is alive. And a will, of course, is just a piece of paper until you pass away.
Okay. And powers of attorney are effective only while the person is alive. Is that right?
Yes.
And I think a lot of people don't understand that either. At least I get a lot of people coming in and saying, I have a power, someone's died, but I have their power of attorney, so I'm going to go to the bank and get the money. Can they do that?
No. And I think, unfortunately, the lines blur a lot with that, and we get that a lot, of course, is people attempt to go to the bank, use that power of attorney, and the person has already passed, and they assume, well, I'm the executor, I'm the agent, it's one and the same.
And absolutely not.
No.
And you do, and it's frustrating for people, I understand this, but you do have to wait a certain amount of time before you get the letters testamentary.
Correct.
Would you explain the process?
Of course. When somebody passes, at that point, the executor is going to go in, speak with the attorney, an application is filed, it's going to be on file with the court, and they're going to have a hearing before they get their letters of testamentary.
And it stays on file with the court before the hearing for approximately how long?
20 days.
All right. So let's just say 3 weeks. And then you get what's called the return date. And at that time, you have to go with your client and stand in front of the judge and give testimony. Is that right?
Correct.
And if it's a lawyer-written will, as a general rule, there's not a lot of a problem.
Correct.
Or not a lot.
There's
not a big problem. I'll say that.
As long as your executor qualifies that day, it's usually not a problem. They will get appointed.
And when you say qualify, what do you mean?
When they actually go to court, they have to make sure they've never been convicted of a crime or filed for bankruptcy.
All right. And they are actually, when they are appointed the executor, they then have to follow the terms of the will. Is that correct?
Correct.
And that means they gather the estate, they pay the valid debts, and the balance gets distributed among the beneficiaries.
Correct.
And I think there's a year, is that correct, to distribute the assets of the estate unless there are extenuating circumstances?
Well, that's how the law is written. Of course, the situation will also depend on the assets, because there are some assets, for instance, let's say crops, that are more difficult to distribute because of the time sequence or their development, their maturity. So yes, but typically, yes, 12 months is when it should be distributed.
I'm from New York. I don't deal with crops a lot, so I didn't know that, actually.
Yeah.
So you're talking about, let's say, farmers down the valley?
Yes, sir.
And that would have an effect on how the estate is distributed among the heirs?
Well, correct. And then you would have to handle it in certain situations. Of course, the lawyer, that's the importance of why you should have a lawyer handling the execution of the will, so that you can know what you might have to file. Because we're going to have to request extensions or keep the court notified or the heirs notified that there may be some delays in the distribution.
And there really is no authority for anyone to act for the estate until those letters testamentary are issued. Is that correct?
Correct.
So, for example, I actually got a call, I think it was yesterday, and somebody said, I have a person who wants to buy the car. Can I sell it to them? And we hadn't even been to court yet and won't go to court for another 2 weeks, and the answer has to be no, because there's no authority to act for the estate until those letters of testamentary are issued. Is that correct?
Yes, sir.
Okay. There are different types of probate, and we mentioned this briefly before, but there's a muniment of title, and that's, I try and explain that to my clients as a shortcut probate, because you don't have to continue on with an inventory and get that approved by the court.
Right.
And it's a little less expensive, in our office anyway, than a full probate. And you always try and talk to your clients about money, because probate is not the least expensive thing in the world, but luckily in Texas, again, we have an expedited system, and because of that, it's a little bit less expensive. Well, it's a lot less expensive than a state like California, and that's why people in California generally create trusts. So let's talk about trusts for a little bit. I have some feelings about them, but what are your feelings?
I think trusts are great in certain situations. So if we're leaving anything to a minor child, anybody with special needs, you're definitely going to set up a trust. And I think sometimes when we don't have anybody that we trust and we have an elderly client who is at potential risk of being taken advantage of, then a trust is something that we think about in that situation.
And we have a couple types of trusts. There are revocable trusts, and those are, to use a legal term, inter vivos trusts, and are not contained in the will. Trusts that are contained in the will are called testamentary trusts, right?
Correct.
Okay. So what are your experiences with those?
Testamentary trusts?
Yeah.
I think testamentary trusts are effective on a number of conditions because people sometimes will write their will, not usually, because most of my clients come in wanting to write their will when they think they're old enough. but I do have clients that come in, they write their will, and they have minor children at the time. And of course, they're pre-planning just in case something were to happen, that they leave a testamentary trust in there. So the child doesn't receive it at 18. Maybe they use it for college, maybe they use it till they're 21, 24, something like that.
It's an important point. So talk about why, what's the magic number, the 18?
Well, 18 is the age of majority. So that's when the individual becomes an adult.
Okay.
In Texas and in most states. And so at that point, of course, the idea, of course, I was a teenager a long time ago too, and I don't know at 18 if I'd have left myself anything, but they become an adult and they should have the maturity to understand what they're receiving.
Well, I think all of us have had this experience. I think it's an excellent point, and people don't really think about this enough. Do you want your kid to get your money when they're 18? Do they have the maturity to deal with it?
Probably not.
Yeah.
I think, just like Victor said, most 18-year-olds, that's a lot of money coming to them, and they're going to buy that fancy new car or go on that fancy trip instead of spreading out the money, paying for college, and actually taking care of the child.
And there are a lot of enticements out there that we would not necessarily approve of, that an 18-year-old says, I want to go experiment with this, that, or the other thing. And if the property had been managed, if the assets, rather, had been managed properly in a trust, that money would grow for that child.
Correct.
And could be used for college, and could be used to get them set up in a business, and could be used for a down payment of a house. But if you don't make those provisions, that money could certainly be wasted, correct?
Very quickly.
All right. And we're going to talk about what you had said in a little bit, because I want to tie it in with guardianship in terms of special needs trusts and that sort of thing. But you also brought up another point of the revocable living trust. And sometimes I'm a fan of trusts and sometimes I'm not. I think maybe 10 years ago, maybe even longer ago, they used to have these seminars where people would come into town, they'd rent a hotel room and say, everybody come, we're going to give you dinner and tell you why trusts are the best, and you don't have to pay an attorney and you don't have to pay probate costs. And that's true if you do the trust correctly. A lot of people don't do their trusts correctly. What problems have you run into, like with living revocable trust?
Well, there's maintenance issues, of course. You have to continue to monitor and see what the items you put in the trust are and what they're doing, i.e. bank accounts, interest rates, even real estate in the account, in the trust. And then the other problems I see with trusts lots of times is the individual, their life changes, their lifestyle changes, a divorce comes about, an injury, a serious medical situation. And so the planning of the trust was beneficial at the moment, but now all of a sudden they need the asset that was in the trust for their own well-being.
And if it is a revocable trust, and usually what happens is, in my experience anyway, it's a revocable trust while both parties are alive. So let's say my wife and I set up a trust for ourselves, and it's the Warwick Family Trust, and we put our assets into it. It's revocable until the first of us dies, at which point it becomes irrevocable. Is that your experience
Yes,
too?
sir.
Yes.
Okay. So you have to be very thoughtful about preparing that type of document. And you also have to follow through. And I think this is what you were alluding to before. You have to put your assets into the trust, or you have to put the assets you want into the trust in it. Is that right?
Correct.
So you have to take some other action. You don't just write the trust and forget about it.
The trust itself is only actionable based on the individual that creates it. The trustees or the trustors, settlers as you call them. So you have items in the trust that you may want to use in certain ways. Nowadays, and I'll just interject this, I use a lot of trusts for asset protection more so. A lot of times the individual homestead doesn't necessarily need to be in the trust unless you just don't want it sold down the road.
Explain what you're talking about when you say asset protection.
Well, in Texas, there are certain assets based on the Constitution that can't be forced sold, which is, for instance, your homestead. You're allowed your homestead the protection to have a place to live. If somebody were to sue an individual and try to collect the debt on their homestead, they wouldn't be able to force the sale on the homestead based on the lawsuit because it is a homestead product.
And protected except in very specific instances.
Yes, sir.
So go on. Finish up what you're saying.
We were talking about the protection of the homestead. Of course, there needs to be a declaration of homestead. There has to have something that they can determine they've declared it to be their homestead. And then on the death of the individual or individuals who have the right to claim the homestead, which actually could extend to a child who is incapacitated, the property can't be touched for forced sale. Now, once all of the homestead requirements or protections have expired due to death, then it's a different issue. The property could be sold.
However, I think, at least as the last time I looked at the law, the proceeds from the sale of a homestead are still exempt for 6 months.
Correct.
And so if that happens, you have 6 months to invest those proceeds into another asset that's exempt.
And right, similar asset.
Right. I think in certain instances, revocable trusts are very beneficial for elderly people. You agree, Magda?
Agree.
And talk about some instances there where you see the benefit.
I think the hard thing when we're talking with somebody who's elderly, and again, it's hard to accept that, but especially if we don't have anybody close by, children move and you're alone. And unfortunately, there's always that risk that we have nobody to turn to, that friend who comes around and starts taking you places. And there's always that risk that that person is going to move in and start getting on the bank accounts. And there's nobody to monitor. So if we set up a trust, then you have that added layer of protection for that elderly individual.
And let's, there are two issues, and I want to make sure we address this. I have to back up just one minute. You were talking about funding a trust. I get lots of trusts. They didn't put anything in it.
Right,
You get a great big trust instrument, and there is nothing in it. And so this whole, the come on at these seminars is you don't have to pay a lawyer, you don't have to go to probate. You know what? In those instances, you have to go to probate because usually along with the trust, there's something called a pour over will that says if I forgot to put anything into the trust, this will does it. So you're going to probate, you're probating the will, getting the assets into the trust and hoping everything works correctly from there. I just didn't want to forget to say that. Now I want to go back here to Magda, and I'm sorry for jumping around like this, but I'm going to use Jane and I as an example again. She's a CPA, so she does all the bills and all the investments and all of that sort of stuff. I don't do any of that at home. And God forbid she should die before I do, it's going to be, I'm going to hold my hands up like that. So as we get older, it might be good for us to do a trust, because if she died, I don't know that I would want to take that over. I would want to have a trust company do it. Now, you can have a number of different kinds of trustees, right? They can be individuals. The individuals can be friends, children, brothers, sisters, or you can have a trust company do it.
The bigger banks do have trust departments, but the limitations as to the size of assets comes into play. But yes, reasonable trust companies that will take reasonable estates, and when I say reasonable, I mean, you know, a smaller estate, under 7 figures, those kinds of things are very far and few between.
Right. We talked about powers of attorney generally. Magda, please explain the difference between the 2 powers of attorney.
Of course, there are 2 types. Medical power of attorney is who you are going to choose to make your medical decisions when you can no longer make those medical decisions. The other type is a statutory durable. I always tell my clients that encompasses everything else pretty much. Wherever you're going to sign, that agent can sign for you, access your bank accounts, make every other decision for you.
Like a business power of attorney.
Yes.
And when do they become effective?
In my office, our office, we say statutory durable power of attorney is effective when you sign it. If you are appointing that agent, you should trust them 110%, so it's effective immediately.
And that's very important. You need to trust whoever you name 110%, because they will be able to make decisions for you. Another important thing is people think that if the person who signs the power of attorney is called the principal. The person who acts under the power of attorney is called the agent.
Correct.
And a big distinction between a power of attorney and a guardianship is that in a power of attorney, and correct me, Victor, if I'm wrong, you're giving somebody the ability to act for you, but you still have the ability to act for yourself.
Correct.
Is that right?
Correct.
And I know we're making a leap here, but again, we're running out of time. In a guardianship, you do not, if a guardianship is granted over you, you don't have the ability to act for yourself any longer. Is that right?
Well, the court will restrict certain aspects of your decision makings, or all of them, depending on what's determined to be your capacity.
And the reason I wanted to bring that up is because people do think if they give a power of attorney to somebody, they are giving up their rights to act for themselves.
Not at all.
Right. That's completely wrong. Oh my goodness. So let's see. I want to make sure my notes that we've covered everything. Oh, I did want to say this. If you need a tax attorney, you need a divorce attorney, you need a criminal attorney, do not come to me. I don't think Magda wants them to come to her. Victor?
No, sir.
Yeah, you want to kind of limit your practice to the areas that you feel comfortable in. Magda and I limit I know yours is a little broader than what we do, but we limit our practice to just probate and real estate. And I know you do real estate. I know you're a fee attorney in terms of being able to close real estate transactions. You do a lot of probate. What else do you do?
We do, of course, guardianship, and we do a lot of other items, i.e. LLCs, corporations. We call them family matters. We represent smaller businesses.
And just for the terms of disclosure, when we can't do something because of a conflict, we send it to you, you might send
Correct.
it to us, and there are other lawyers we refer to. Guys, I want to thank you very much for coming and doing this with me today. I think it's helpful. I had fun. It went quicker than I thought it would. And I want to thank Mary again for letting us do this today. Thanks, everybody.
Thanks.
Thank you.